Hi, I'm Brodie McLeod, and once again, for whatever reason, you're watching my YouTube channel. I try to cover current affairs, things to do with my life, sort of philosophical and political beliefs, and content that I think people will find interesting. I got really badly attacked about a week ago. This guy, I got up at 4:30 in the morning because I got insomnia. This guy ran down the corridor, took his shirt off, started getting up in my face, and was inviting me to take the first punch so that he wouldn't get in trouble. Just a piece of shit, basically. Just some fucking deluded, psychotic parasite who's in a bent psychiatric unit. And I say that because they didn't do anything about it. Tried to phone the police several times. Let's have a look at my Twitter account. So this was on this was on the 7th of May, and it's now the 16th of May. So about 10 days ago, this report took place. You can see here that I phoned 101 at 10:40 in the morning, 10:41. Again, sorry, that was on the 8th of January. So yeah, I phoned them at 6:20 because I'd heard nothing. I phoned them an hour later at 7:20. And then I phoned them later on that day at 15:46 because they told me that based on the 999 calls that I'd made, one at 4:56 after the attack had initially taken place, and they said they were sending two officers out to arrest a person and to assess my injuries. I phoned up again 2 hours later, and they just said that they were on their way and that they'll be there in a bit. And then I phoned up like an hour and a bit later again to say, where are these two officers? What's going on? Like, how the fuck am I supposed to be safe? Like, the thing was that if you've ever been to a psychiatric unit, which I hope you haven't, they have something called the segregation suite, which is kind of like the equivalent of a padded cell. It's like a place where people can be put, if they're violent towards people, they can be put into these segregation units where they can't hurt anybody and they're in their own. It's like a locked single cell. When this guy attacked me, it was all on CCTV. They just kind of failed and broke every rule in the book, basically. They didn't put the guy on into the segregation unit to keep me safe. He continued to threaten me with violence, make open accusations that he'd been gang raping my sister Lily Allen, my half sister, who basically, long story short, her kids were killed in a hospital in Warrington in 2024. The corpses were brought down to Cygnet Western Supermare, and they were carved up and force fed to her, and then she was forced to watch videos of her children being murdered over and over again on repeat, whilst getting gang raped by the patients and the staff. Her new album, West End Girl, has nothing to do with her breakup with David Harbour. It's to do with the fact that she was on her Miss Me podcast, visibly, absolutely traumatized and on the verge of tears the whole time, because she wasn't actually in New York or at any other location other than here in Cygnet Hospital. They're still doing it. They're doing it last night, they're doing it yesterday, they're doing it the day before. And this guy was like openly like just taking the piss, saying that like he'd been raping my half sister. I know if you Wikipedia it, it says we're not related, but it's because of a whole load of official secret stuff that nobody's allowed to know about, as fucked up as that sounds. But Keith Allen's not a real dad. Diorsa McLeod is a real father. I'll show you a picture of him one day. You can probably find it on my Facebook page if there's an album for cover photos. So they didn't put this guy on a 1-to-1 either, right? So if you do something wrong to somebody, you get put on a 1-to-1 or even a 2-to-1, where wherever you go, you have staff which follow you around to make sure that you don't violently assault anybody or break anything or do anything which is going to cause harm or loss or damage to anybody else. And then, just to compound that, so they didn't call the police, they didn't restrict him from being on the open ward where he was able to attack me again. They didn't call the ambulance. They didn't arrange the hospital appointment either. I had to do that myself. And he's been still just walking around the ward threatening me and being openly sort of like obtuse and sort of threatening and violent towards me, in this kind of like sardonic, sarcastic, implicatory way, and they've moved him into the door next door to mine, like on the other side of that wall behind me. The guy sat in bed right now, and I had to go to the Bristol Eye Hospital because I've thought that I've still got partial vision in one eye. Like if I close my one eye, I can't really see very well out of this eye. This is 10 days later. I've still got bruising and swelling on my eye. Like I really did take he came in. The staff did nothing. Like they about 4 or 5 staff were watching this altercation where this guy had taken his shirt off and was shouting in my face, like claiming that he wanted to fight. And I just disengaged and just tried to go and get a cup of coffee, which to replace the one he'd ripped out of my hand and thrown all over the ward and all over me. Yeah, I mean, I can't. Signet management, when they looked at the CCTV footage, said they thought it was brutal. And yeah, I mean, eventually I did get a video conference sort of 2 or 3 days ago with the police officer to make a statement. There was further verbal threats that were issued a couple of days ago, and I phoned up to make the investigating officer apparent and aware of that. But I'm not allowed to know his name. I don't know what this guy's actually called. Signet won't tell me his name because of data protection. The police won't tell me his name, which I think is that's what this video is about. It's just the absolute absurdity. I can walk into somebody's house, beat the fuck out of their mum, and then, move into a house across the street from them, or start drinking in their local pub. Or, I don't know, there's 101 hypothetical scenarios where knowing the name of somebody who's been violent towards you or has tried to attack you or even tried to kill you is protected via data protection. It's fucking absurd, and I don't agree with it. And here's a little bit of writing all about it. So it's entitled "The Intersection of Data Privacy, Clinical Negligence and Victim Vulnerability in Psychiatric Inpatient Settings. The management of violence and aggression within psychiatric inpatient facilities represents one of the most operationally and ethically complex intersections of clinical governance, criminal justice, and the data protection jurisprudence. When a vulnerable patient is subjected to a serious, unprovoked assault by another patient within this ostensibly therapeutic environment, the immediate aftermath must be governed by rapid clinical intervention, stringent safeguarding protocols, and robust immediate police action. However, a systemic and highly detrimental paradox currently defines the operational landscape. Statutory frameworks originally designed to protect civil liberties, privacy, and proportionate care are frequently weaponized or grossly misapplied to the absolute detriment of the victim. This comprehensive report examines a highly specific yet increasingly prevalent systemic failure, a paradigm in which a victim of a serious CCTV recorded assault within a psychiatric hospital is systematically denied the identity of their assailant under the rigid guise of data protection and patient confidentiality. Compounding this information embargo is a catastrophic failure in the hospital's overarching duty of care. This failure is explicitly evidenced by the clinical decision not to utilise the established segregation protocols to refuse to utilise de-escalation suites, and the failure to assign 1-to-1 or 2-to-1 nursing supervision ratios. Most egregiously, this negligence culminates in the institutional decision to move the assailant into the bedroom directly adjacent to the victim's room. Furthermore, this profound negligence is exacerbated by procedural inertia within the corresponding police force, characterised by the utilisation of delayed online interviews and voluntary attendance protocols rather than executing an immediate arrest. Through an exhaustive and critical analysis of the Data Protection Act 2018, pre-charge anonymity doctrines, clinical negligence frameworks, and modern policing guidelines, this report elucidates precisely why the current legal architecture ostensibly protects criminals at the expense of victims. Furthermore, the analysis constructs an extensive framework of detailed hypothetical scenarios. These scenarios exhaustively demonstrate how the enforced anonymity of an assailant, combined with the physical proximity and delayed law enforcement action, leaves the victim acutely and perpetually vulnerable to future harm, both within the immediate clinical environment and the following subsequent discharge into the broader community. So Section 2 is entitled Jurisprudential Shield, how data protection insulates criminal suspects. So the systemic withholding of an assailant's identity from their victim is fundamentally rooted in a rigid, deeply risk-averse interpretation of contemporary data protection legislation and evolving domestic case law regarding privacy rights. Institutions increasingly prioritise the avoidance of data breach liabilities over their fundamental safeguarding duties. So pre-charge anonymity and the ZXC versus Bloomberg doctrine, the jurisprudential cornerstone protecting the identity of the criminal suspects prior to the laying of formal charges, is the landmark Supreme Court ruling ZXC versus Bloomberg LP UKSC 5. That's case law. So when something goes through court and they prove it in the Supreme Court, it becomes law in Britain. In this ruling, the Supreme Court conclusively established that individuals who are subject to active criminal investigations but who have not yet been formally charged by the Crown Prosecution Service possess a reasonable expectation of privacy regarding information related to that investigation. The judicial rationale is that the disclosure of a subject's identity prior to the formal establishment of a prima facie case can cause irreversible reputational, economic and personal damage. The court noted that an individual's reputation will usually be adversely affected by the publication of such information, deeply impacting their right to respect for a private life under Article 8 of the European Convention of Human Rights. While the ZXC versus Bloomberg litigation primarily addressed the publication of investigative details by international media organisations and financial journalists, the underlying legal principle has deeply permeated public sector information governance. Hospitals and police forces now routinely utilise this precedent to argue that disclosing the name of an assailant to a victim, even when the assault is incontrovertibly captured on ward CCTV and involves zero ambiguity regarding the perpetrator's physical actions, constitutes a breach of Article 8's rights and misuse of private information. Legal expectation of privacy is weaponised to create an absolute informational blockade, completely disenfranchising the victim from participating in their own risk management. So the Data Protection Act 2018 and the Crime and Taxation Exemption. So the UK General Data Protection, UK GDPR, and the Data Protection Act 2018 established exceptionally strict parameters around the processing, sharing and transparency of personal data. When a victim of an assault within a clinical setting formally demands the name of their attacker to ensure their own future safety, data controllers frequently cite the Crime and Taxation Exemption outlined in paragraph 2 of Schedule 2 of the Data Protection Act 2018. Now, this specific statutory provision exempts organisations from standard transparency obligations and individual data rights if complying with them would prejudice the prevention or detection of crime or the apprehension or prosecution of offenders. In practice, this mechanism means that if a hospital shares CCTV footage of the subject's identity with the police to facilitate a criminal inquiry, the hospital's information governance team will claim that revealing the suspect's identity to the victim might prejudice the ongoing investigation. The paradox inherent in this application is profound. The exemption was specifically designed by legislators to facilitate law enforcement by preventing suspects from using subject access requests to discover if they are under investigation. Yet it is simultaneously used to establish an informational blackout that disempowers the victim. The hospital claims that telling the victim the name of the person who physically assaulted them might somehow alert the attacker or contaminate the evidence, despite the fact that the attacker is entirely aware they committed the assault and the evidence is already secured via CCTV. The veil of patient confidentiality and institutional insulation. So in psychiatric inpatient settings, the refusal to name an assailant is further insulated by the highly entrenched doctrine of patient confidentiality. Medical records, admission status, and patient identities cannot be usually disclosed to third parties without explicit consent from the individual, even in cases of homicide inquiries, unless a judge explicitly orders the disclosure in the public interest. At the start of an independent homicide or serious incident inquiry, the inquiry panel often faces the absurd requirement of seeking the killer's permission to review their medical records. Critics, advocacy groups, and independent reviewers have repeatedly noted that the mental health trusts frequently invoke patient confidentiality to refuse information to victims and their families. This invocation is not necessarily deployed to protect the patient's privacy, but rather to obscure profound systemic problems, inadequate assessments, catastrophic ward management, and chaotic clinical environments. The complete absence of an independent immediate review mechanism for information deemed confidential allows hospitals to unilaterally enforce a veil of secrecy. This effectively prioritises the rights of the perpetrator over the safeguarding needs of the victim, while simultaneously protecting the institution from immediate external scrutiny regarding their failure to maintain a safe therapeutic environment too. So the safeguarding paradox, statutory contradictions in information governance. So what renders this informational embargo farcical and legally contestable is the existence of explicitly drafted statutory mechanisms designed precisely to bypass confidentiality in cases of severe risk. The system's failure is not due to a lack of legal avenues for disclosure, but a systemic reluctance to utilise them. Section 8 of the Data Protection Act 2018, the ignored safeguarding mandate. The Data Protection Act 2018 is frequently mischaracterised by clinical administrations as an absolute barrier to data sharing. However, Schedule 8 of the Data Protection Act 2018 provides specific, robust conditions for processing personal data without consent for safeguarding purposes. Specifically, it authorises the disclosure of data where it is necessary to protect an individual at risk from physical, mental, or emotional harm, and where obtaining consent from the data subject, the assailant, is not reasonably possible or would prejudice the investigation that is needed. So the Information Commissioner's Office guidance and safeguarding policies explicitly state that data protection law is not and should never be a barrier to sharing information, when a failure to do so would compromise the safety or well-being of a vulnerable individual. Furthermore, information can be shared lawfully between agencies and with relevant individuals when the public interest is in preventing serious crime and protecting physical safety outweighs the public interest in preserving confidentiality. By choosing to prioritise the assailant's privacy over the Data Protection Act's explicitly defined safeguarding exemptions, the hospital demonstrates a profound misapplication of the law, driven by a culture that fears ICO fines for data breaches more than it fears the physical harm of its patients. Then you've got Clare's Law, you might have heard of this, and Sarah's Law, the hypocrisy of risk disclosure. So the absurdity of the hospital's refusal to identify the attacker is most starkly highlighted when contrasted with other areas of UK law designed specifically to breach data protection for the sake of victim safety. So under the Domestic Violence Disclosure Scheme, DVDS, commonly known as Clare's Law, individuals have the right to ask the police if their current or former partner has a history of abusive or violent behaviour. If the police ascertain that that risk exists, they utilise the right to know mechanism, meaning the police will proactively breach the offender's data privacy to share their criminal history with the potential victim to prevent future harm. Similarly, the Child Sex Offender Disclosure Scheme, Sarah's Law, allows parents and guardians to inquire about the risks posed by individuals with access to their children. Both of these operational schemes acknowledge a fundamental jurisprudential truth. The right to physical safety supersedes the right to privacy. They establish that knowing the identity and violent history of an abuser is a fundamental prerequisite for a victim to take protective distance. Yet, in the psychiatric inpatient setting, this logic is entirely inverted. A victim who has already been violently assaulted, an event verified and captured on camera, is denied the very informational transparency that Clare's Law would proactively afford a person who only suspects they might be at risk. The hospital and the police use the Data Protection Act 2018 and the ZXC pre-charge anonymity precedent as an impenetrable shield. They ignore the explicit provisions within Section 8 of the Data Protection Act 2018. This selective, highly biased application of the law suggests an institutional culture that's complicit in the installation of violent offenders, prioritising the avoidance of administrative data litigation over upholding fundamental human rights of victims. So clinical negligence and the complete collapse of the duty of care. The overarching failure in the presented scenario is the psychiatric hospital's complete and systemic abandonment of its legal clinical duty of care. When an inpatient violently assaults another inpatient, the hospital is legally, ethically, and clinically bound to implement immediate restrictive interventions to ensure the safety of the victim and the wider therapeutic environment. The failure of segregation, seclusion, and zoning protocols. So the National Institute for Health and Care Excellence, NICE guidelines, NG10 mandates explicit protocols for the short-term management of violence and aggression in psychiatric sessions. When serious violence occurs, clinical staff are expected to utilise a hierarchy of interventions. These may culminate in the use of a seclusion or long-term segregation, particularly when an individual poses a constant feature of risk. Segregation is strictly defined in statutory guidance as a situation where, to reduce sustained risk of harm posed by the patient to others, the patient is not allowed to mix freely with other patients on the ward. Seclusion involves the supervised confinement and isolation of a patient away from others. Furthermore, the hospitals utilise safety zoning or RAG-rated red, amber, green systems to allocate patients to specific areas of a ward based on risk criteria. High risk, highly volatile patients, red zone, are supposed to be structurally and procedurally separated from stable or highly vulnerable patients. That's the green zone. In the presented scenario, the hospital completely failed to place the assailant in a segregation unit, a seclusion suite, or a de-escalation area, most egregiously, in an act that defies all basic principles of risk management. They allocated the attacker to the bedroom immediately adjacent to the victim's room. This action directly violates the fundamental principles of safety zoning and environmental risk mitigation. It creates a highly volatile, inescapable pressure cooker environment for the victim. The absence of enhanced observation. Following a serious violent incident, standard psychiatric operating procedures dictate the immediate implementation of enhanced observations. This is commonly referred to as 1-to-1 or 2-to-1 nursing ratios, requiring registered mental health nurses to maintain continuous, unbroken visual and physical supervision of the aggressor to prevent further harms. Basically, they got either one person or two person following them around all the time and watching and everything they do. They leave their door open and sit with a chair just outside their door so they can hear everything they're saying and doing, and they make sure they don't hurt anybody else. The Care Quality Commission, CQC, closely monitors these practices, noticing that safe staffing levels and appropriate supervision are fundamental to maintaining a safe ward environment and respecting the human rights of all patients. The hospital's failure to assign a 1-to-1 or 2-to-1 staff ratio to the assailant means the attacker is free to roam the communal areas of the ward, including the corridors shared with their victim, completely unmonitored. The tort of clinical negligence and psychiatric injury. The hospital's actions transition from merely poor clinical practice into highly actionable clinical negligence. Under a domestic tort law, a psychiatric hospital owes a non-delegable duty of care to protect its patients from foreseeable harm, including harm caused by others. To prove clinical negligence, a claimant must demonstrate that the professional had a duty of care, failed in that duty, and that this failure caused harm. By knowingly placing a violent, unsupervised assailant in the room next to their victim, the hospital has unequivocally breached its duty. This breach creates a highly foreseeable risk for both further physical assault and severe secondary psychiatric injury, such as complex post-traumatic stress disorder. The hospital cannot claim the secondary harm was unforeseeable when they actively engineered the proximity. Then you've got 4.4 European Court of Human Rights positive obligations. Beyond domestic torts, the state, acting via the NHS trusts, holds positive obligations under the European Convention of Human Rights. Article 2, right to life, and Article 3, prohibition of inhuman or degrading treatment, impose a procedural or an operational obligation on the state to protect individuals within its care. The state must take reasonable steps to protect a person when it knows or ought to know of a real and immediate risk of violence from a third party. Subjecting a victim to the continuous unmitigated terror of residing next door to their unmonitored attacker while simultaneously denying the victim the basic information required to process the trauma arguably crosses the threshold into degrading treatment prohibited by Article 3. The hospital's complicity effectively traps the victim in a state of perpetual psychological torture. Procedural paralysis, the danger of police delays and remote interviewing. The extreme vulnerability of the victim is critically compounded by the procedural methodology employed by law enforcement. In a situation involving a violent assault captured on CCTV, immediate arrest under the Police and Criminal Evidence Act 1984 and the imposition of strict bail conditions such as non-contact order would typically provide the necessary legal mechanism for protecting the victim. However, policing strategies within institutional mental health settings frequently diverge from standard robust investigative practice. So the misapplication of voluntary attendance. So instead of enacting a prompt arrest under Code G of PACE, officers frequently utilise voluntary attendance or voluntary interviews for suspects located in psychiatric hospitals. The police rationale often rests on the flawed assumption that because the subject is already detained under the Mental Health Act or is an informal patient in a locked facility, they're securely contained. Therefore, the statutory necessity for criteria for arrest, such as preventing the suspect from causing physical injury to another person, are ostensibly managed by the hospital's clinical staff. However, as established in Section 4, the hospital has completely failed to contain the risk, leaving the attacker unmonitored next door. Investigations by His Majesty's Inspectorate of Constabulary and Fire Service Rescue Service have heavily criticised the overuse and poor practice surrounding voluntary attendance, particularly in cases of domestic and violent crimes. The critical systemic failure of utilising voluntary attendance is that it fundamentally circumvents the bail framework. Without a formal arrest, the police cannot legally impose pre-charge bail conditions. They cannot issue a legal boundary requiring the assailant to maintain a specific distance from the victim. The police have effectively outsourced the physical protection of the victim to the hospital that's already proven grossly negligent. So the fallacy of danger and the delayed online interview. The modern integration of digital policing tools has led to the widespread adoption of remote or online interviews. While these systems can be cost effective, reduce travel time for offenders, and provide scalable frameworks for volume crime, their application to suspects of serious violent assaults in active inpatient settings introduces a catastrophic temporal delay. Establishing the logistics for a legally compliant remote interview under PACE Code C and Code E is highly arduous. It requires coordinating the secure digital availability of the investigating police officers, the suspect, an appropriate adult, which is absolutely mandatory for vulnerable or mentally ill suspects under PACE Code C, and the subject's legal representation. Consequently, the process to simply secure the initial interview can be delayed for a week or more. During this extensive waiting period, the suspect remains entirely uncharged. The ZXC versus Bloomberg privacy protections remain fully and legally enforced, and the hospital is left to manage an active, unrestrained aggressor and their highly traumatized victim within the exact same physical footprint. The online interview transforms an acute incident into a protracted hostage situation for the victim. So extensive hypothetical scenarios, the cascading vulnerabilities of assailant anonymity, the convergence of data protection, shielding, protracted police delays, and profound clinical negligence creates a highly volatile, inescapable environment for the victim. Because the victim does not know the actual identity, the full legal name of the person who violently attacked them, they're stripped of all personal agency and left entirely reliant on a failing, apathetic system. Furthermore, the police are now involved in seeking a voluntary interview. The assailant is highly likely to be aware of the active investigation. This awareness inevitably escalates their hostility, their clinical paranoia, and their motivation for retribution or witness intimidation. Following hypothetical scenarios are constructive to exhaustively illustrate how the systemic refusal to provide the assailant's identity directly facilitates severe vulnerability, psychological trauma, and potential re-victimization. These scenarios span the timeline from the immediate patient admission to long-term discharge into the community. So here's one scenario. Scenario A, the retaliatory ambush in communal spaces. This is at a ward level. So here's the context, right? The victim remains on the psychiatric ward. The assailant, aware that the police are arranging a delayed voluntary online interview in the coming week, realizes that the victim is actively pressing charges. Because the hospital has not assigned a 1-to-1 or 2-to-1 staffing ratio and placed the assailant in the adjacent bedroom, the assailant has total unmonitored freedom of movement within the unit's communal areas, corridors, and dining spaces. The mechanism of vulnerability: the victim is acutely traumatized, hypervigilant, and terrified of leaving their room. However, because the victim does not know the assailant's legal name, they cannot formally log specific actionable intelligence with external safeguarding agencies or their own legal counsel. Even if I had a solicitor, I couldn't tell them the person's name. If the victim wishes to apply to the family courts or civil courts for an emergency non-molestation order or an injunction to legally force the hospital to separate them, their solicitor cannot draft the legal paperwork. The respondent is legally a John Doe. Registering civil legal aid and injunction frameworks utterly useless. The outcome: the assailant, unrestrained by any formal police bail conditions, legal injunctions, or internal ward segregation protocols, simply awaits the limited ward staff are occupied, simply waits until the limited ward staff are occupied with an indecent elsewhere. The assailant breaches the victim's personal space or waits immediately outside the adjacent bedroom door and executes a violent retaliatory ambush. This assault is specifically designed to coerce the victim into dropping the police charges prior to the delayed online interview. The victim's ability to identify the attacker legally paralyzed their ability to secure preemptive external legal protection. Here's a different scenario, which is entitled The Subversion of Witness Testimony and Ward Intimidation. So the context: the assault was witnessed by other vulnerable patients on the ward. The police, operating on their delayed online interview timeline, have not yet spoken to these key witnesses. There were many staff who witnessed what happened as well. Prior to the actual assault taking place, there was a very loud and violent altercation between us. The mechanism of vulnerability: the attacker, residing next door and moving freely without one-to-one supervision, systematically approaches the other patients. The attacker utilizes threats and coercion to force the witnesses to align their stories, ensuring they will claim the victim provoked the attack. The victim, attempting to gather support or warn the other patients, is unable to accurately describe the specific named threat to external advocates like the independent mental health advocate, because they cannot formally identify the perpetrator in their complaints. The outcome: by the time the police finally conduct their online interviews a week later, the entire ward's testimony has been contaminated by the attacker's unmitigated intimidation campaign. The police drop the case due to the conflicting witness statements. The attacker is emboldened and the victim is denied justice because the hospital prioritised the attacker's privacy and comfort over securing the integrity of a crime scene. Here's another scenario: the malicious counter-allegation and legal paralysis. So the assailant, highly manipulative and acutely aware of the hospital's systemic failures and prioritisation of data protection, realises that the hospital is implicitly insulating them. They note the lack of segregation and the delayed hands-off police response. To preempt the police investigation, the assailant decides to file a malicious counter-allegation, claiming the victim actually assaulted them first. The mechanism of vulnerability: the police, faced with cross-allegations on a psychiatric ward, are obliged to investigate both parties. The victim's legal defence is immediately and critically compromised. To demonstrate that the assailant is a malicious actor with a documented history of violence or a specific pattern of predatory behaviour, the victim's legal representative needs to run background checks, review local court registers, or seek character witnesses. However, the victim cannot tell their own defence solicitor who the accuser is, other than describing them as the man in the next room. The outcome: the victim is subjected to the severe trauma of arrest and formal police interview as a suspect. The hospital, strictly bound by their interpretation of patient confidentiality, refuses to clarify the identities or clinical histories to the victim's defence team. The victim is dragged through the criminal justice system, their psychiatric recovery destroyed, because the protective shield of data privacy has afforded the attacker the absolute anonymity required to weaponise the police rule against the true victim. Scenario D: the post-discharge community ambush. So both the victim and the assailant are eventually discharged from the inpatient psychiatric facility. Because they were housed in the same regional hospital, it's highly likely they'll reside in the same local authority, integrated care system, catchment area, or utilise the same community mental health pathways. The mechanism of vulnerability: the victim, proactive in their recovery, joins a local community mental health support group, registers with a specialised outpatient therapy clinic, or moves into a local supported housing. Because the hospital strictly enforced the patient confidentiality and data protection laws, the victim never learned the assailant's name. Consequently, the victim cannot ask the organisers of the support group, the managers of the housing association, or their community psychiatric nurse, "Does so-and-so, name insert here, attend this facility? Am I safe here?" The outcome: the victim walks into a community group therapy session, a local pharmacy, or a shared kitchen in a supported accommodation, and comes face to face with their attacker. The psychological shock triggers an immediate, severe trauma response, potentially reversing months of psychiatric recovery and resulting in actionable secondary psychiatric injury. Furthermore, without the highly structured, albeit flawed environment of the ward, the assailant is entirely free to physically attack the victim again. The victim's fundamental right to physically avoid their abuser is entirely negated by the enforced informational asymmetry. So here's another scenario: third-party association and the social orbit trap. So in this context, several years have passed since the violent assault. Police investigation fatally delayed by the initial online interview protocol and lack of immediate evidence gathering ultimately collapsed. The Crown Prosecution Service deemed there to be insufficient evidence, or the assailant received a minor confidential community resolution. Crucially, the assailant's name was never entered into public record via a court charge or a public trial. The mechanism of vulnerability. The victim forms a new romantic relationship, makes a new close friend, or begins working closely with a colleague. The new acquaintance frequently talks about their brother, cousin, or close friend, referring to them affectionately by their first name. Because the victim does not know the full legal identity of the individual who brutally assaulted them on the psychiatric ward, they cannot cross-reference the name or recognise the impending danger when invited to a social gathering hosted by this new acquaintance. The outcome: the victim attends the private social event and unwittingly walks directly into the private residence of the assailant, or a highly isolated environment entirely controlled by the assailant's associates. The victim is trapped. The assailant, recognising the victim from the hospital and holding a long-term grudge over the initial police involvement, has the victim at their absolute mercy in an unmonitored environment. This catastrophic failure of physical safety is a direct, foreseeable downstream consequence of the hospital's rigid adherence to data protection exemptions, which prioritise the suspect's privacy over the victim's long-term physical security. Then there's another scenario: digital stalking and law enforcement blind spots. So during the inpatient stay, the assailant easily learns the victim's full name, which is frequently visible on nursing whiteboards, handover sheets, unattended care plans, or through casual ward interactions. The hospital, however, successfully continues to protect the assailant's identity from the victim. Following discharge, the assailant decides to pursue a relentless campaign of harassment and intimidation. The mechanism of vulnerability. So the assailant utilises social media, encrypted messaging apps, and digital platforms to stalk, harass, and issue graphic death threats to the victim using anonymous or pseudonymous accounts. The victim reports this severe cyberstalking to the police, noting that they strongly suspect it's the individual who attacked them in the psychiatric hospital. However, because the victim cannot provide the police with the legal name of the original attacker, the police treat the digital harassment as a new low-level unresolved crime rather than a highly dangerous escalation of a known violent offender. The outcome is that police fail to link the digital harassment to the historical hospital assault due to a siloed data system, overwhelmed cybercrime units, and the lack of a named suspect in the victim's initial complaint. The victim is subjected to months of severe psychological torture. If the victim knew the name, they could immediately have provided it to the police, allowing law enforcement to rapidly cross-reference IP addresses, examine historical cell tower data, or execute a targeted search warrant. The DPA's 2018 protections intended to shield sensitive data have been completely inverted to provide an impenetrable operational shield for a cyberstalker. So then you've got employment and vocational proximity. So here's a context that might occur. The victim, as part of their rehabilitation, enters a back-to-work scheme, vocational training program, or volunteer organisation specifically tailored for individuals recovering from severe mental health crises. The mechanism of vulnerability. Because these programs are often utilised and draw from the same regional clinical commissioning groups, there is a high statistical probability that the assailant may also be enrolled in the same or an adjacent program. The victim, attempting to safely reintegrate into society, is unable to vet the participant list of these programs because they do not have the name of the threat. The program coordinators, bound by their own GDPR obligations, cannot disclose participant lists to the victim indiscriminately. The outcome of that is that the victim arrives at a highly stressful new job or training environment, only to find they're assigned to work on the same team or in the same physical office as their attacker. The resulting panic attack and trauma forces the victim to abandon the vocational program, severely stunting their economic and social recovery. The state's insistence on protecting the attacker's identity has directly resulted in the victim's exclusion from the workplace. So synthesis and strategic implications. The operational situation described throughout this report is not merely farcical, it represents a profound systemic failure of multiple interconnected statutory frameworks converging to protect a violent offender at the direct catastrophic offence of a victim's physical safety and psychological recovery. The system, through a combination of bureaucratic cowardice, misapplied jurisprudence, and resource constraints, effectively sacrifices the innocent party. First, the legal shielding provided by the strict operational interpretation of the Data Protection Act 2018 and the pre-charge anonymity doctrine established in the case law effectively legally gags institutions from identifying assailants to their victims, while these legal doctrines are fundamentally designed to prevent reputational damage to innocent suspects facing unfounded allegations in cases of verified CCTV recorded violence within closed clinical settings. These laws become tools of victim subjugation and institutional cover-up. The refusal to utilise the explicit safeguarding exemptions within Schedule 8 of the Data Protection Act 2018 highlights a system that fears administrative data litigation more than it values human life. Second, the profound clinical negligence demonstrated by the hospital is indefensible. The failure to utilise established violent management protocols such as segregation, seclusion and one-to-one observation, and their highly absurd, dangerous decision to place the assailant in the adjacent room constitutes a severe, actionable breach of their non-delegable duty of care. This environment of an engineered proximity directly violates the positive obligations of the state under Article 3 of the European Court of Human Rights and invites substantial litigation for secondary psychiatric injury. Third, the procedural ineptitude of law enforcement exacerbates the clinical failures. The reliance on voluntary attendance and protracted delayed online interviews by police forces circumvents the immediate protection affordable by a formal arrest and strict bail conditions. By failing to arrest, the police leave the assailant legally unrestrained and embedded within the victim's immediate physical environment. Ultimately, as demonstrated by the exhaustive hypothetical scenarios, denying a victim the identity of their attacker ensures that the victim remains in a state of perpetual, inescapable danger. They're stripped of the fundamental ability to secure civil legal injunctions, screen their future community environments, protect their social networks, or defund themselves against digital infiltration. Until the illicit legislative guidance dictates that the physical safeguarding of a victim unequivocally overrides the suspect privacy in instances of verified institutional violence, victims will continue to be marginalised by the very systems mandated to care for them. Data protection in this specific context has entirely ceased to become a shield for the innocent and has become an impenetrable cloak for the guilty.